Academic Affairs, Dr. Siti Hamidah, and the distinguished speakers, Associate Professor Dr. Syahrul Mizan bin Ismail, Dr. Panita Kaisern, Prof. Yin Yin Min, Ms. Yuyun Wahyuningrum, and Mrs. Rika Kurniati, PhD. I also welcome all participants who attend this Brawijaya International Law Conference, which is organized by the Faculty of Law, Universitas Brawijaya. Ladies and gentlemen, on this occasion, I would like to inform you the agenda of the event, the opening remark by Dr. Siti Hamidah, and followed by the presentation that will be delivered by the 5 speakers. And after that, we will open a question and answer session, which will be led by the moderator, Ms. Francisca Ayulistia. Ladies and gentlemen, to begin with, I would like to invite Dr. Siti Hamidah, Vice Dean of Academic Affairs, to deliver his opening remark. Please welcome.
Thank you, Belinda. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Honorable all presenters and participants, especially presenters in panel sessions 3 and 4. I will in rundown Dr. Syahrul Mizan bin Ismail from UK, Malaysia, Dr. Panita Kaisern from University of Payau, Thailand, Prof. Yin Win from Taungji University, Myanmar, Ibu Yuyun Wahyuningrum, and Ibu Rika Kurniati. Good morning. Universitas Brawijaya, since declaring as a world-class university, has various academic programs and activity. And today, the second day of our international conference that held by International Law Department, we will continue this activity with interesting topic about the current issues of human rights. We know that human rights issues will never be finished to be discussed. And the COVID-19 pandemic has created uncertainty in all matters, including human rights. And in the midst of a world full of uncertainty, it certainly takes a genuine commitment by countries to cooperate with each other in solving humanitarian cases. Our contribution as academics and practitioners are also considered important for the progress of the development of international law. And according to the aims of this conference, there are 3 points. First, provide knowledge and understanding about the current issue of human rights. Secondly, to elaborate the thought of scientists and human rights practitioners from various countries. And the last, increase the number of lecturer and student publication. And we all hope these aims can be achieved. Before I end this remark, on behalf of the Faculty of Law Universitas Brawijaya, I would like to express my appreciation to all of you for your cooperation in this event, and especially to the team from International Law Department. Thank you for organizing this event. We will look forward to other activities. May God bless everyone with peace, health, and good life. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Siti Hamidah. And now we are moving on to the main session. And from this now on, this session will be led by the moderator, Ms. Francisca Ayulistia, as International Law Lecturer. And without further ado, please welcome Ms. Francisca Ayulistia, and the time is yours.
Thank you, Ms. Alinda. Assalamualaikum warahmatullahi wabarakatuh. And good morning for everyone. Thank you for welcome to second day of second Brawijaya International Law Conference with the theme International Cooperation in Promoting and Protecting Human Rights, Opportunities and Challenges in the Midst of Uncertainty. For today we have several speakers. For the first speaker would be Dr. Panita Kaisern from University of Payau, Thailand. The second speaker would be Ms. Yuyun Wahyuningrum, the representative of Indonesia at Asean Intergovernmental Commission on Human Rights. And third speaker, Ms. Rika Kurniati, SHMA PhD from Brawijaya University. And the fourth speaker would be Associate Professor Dr. Syahrul Mizan bin Ismail from University Kebangsaan Malaysia. And the last would be Professor Yin Yin Min from Taungji University, Myanmar. Before we start, I will read the CV from Dr. Panita Kaisern. Dr. Panita Kaisern.
The first one, right?
Yes.
Okay.
Yes, Dr. Panita. Yes, you'll be the first one. Yeah, I will read the curriculum vitae first. Dr. Panita Chason PhD is a lecturer from School of Political and Social Science, University of Thailand. Previous education, she graduated from the International Relations Retsumeikan University, Kyoto, Japan. And usually the area of interest of Dr. Panita Choyson is civil military cooperation, military operation other than war, human security, and Japan security policy. That's, without further ado, maybe I will give the time to Dr. Panita Choyson. Time is yours.
Okay, thank you very much and good morning everybody again and สวัสดีค่ะ in Thai สวัสดีค่ะนะคะ Let me actually I'm quite familiar with Microsoft Teams rather than the Zoom. How to share the screen? So I press the share screen and then click the screen, right? Press the screen and then share, right? Do you see my PowerPoint?
Yes.
Ah,
Yeah, I can see that.
okay. Okay, thank you very much for your invitation. And the topic that I would like to share with you today, is about the legal frameworks on the civil military cooperation in humanitarian assistance and disaster relief. But first of all, before I start my presentation, there's a few things that I would like to let you know. As you can see that I'm from the international relation and political science field, and my area of interest focus on the military role in humanitarian affairs and civil military cooperation, and as well as the military operation other than war. This means I'm not the expert on international law or on human rights, and this topic is only a part of my own process research. So for today, I have no, how should I put it, comprehensive research finding or conclusion for you. So what I will do today is just to point out some key concern or controversial issue that can be found from the selected legal framework, and to share my voice for the further discussion. So all comments and suggestions from all of you are very, very welcome. Okay, shall we start? Okay, let's start. We are better start with the post-Cold War world, the world where the scope of the term security has been expanded or widening from the traditional security, which means the security of the state, to the non-traditional security, or in another term, security of the human being or human security. The world where the range of the military operation has also expanded from the war fighting mission to the military operation other than war, which can be conducted in both combat or non-combat situation, and in either war environment, conflict environment, and peacetime environment, which you can see in the table on your right-hand side or left-hand side, right-hand side, right? Okay. And all of these changes in international security regime brought about some ideological debates among some scholars in the field and among some military commander on the subject of the military in humanitarian world. So here we are some debatable issue. The first one concerning with the way we define the term security affair and humanitarian affair. So should we still define the term security affair as the military domain affairs only, while the humanitarian affairs mean the civilian domain affairs or not? Should we define in that way nowadays? Or the issue, the matter of military operation other than war, can this operation be also the primary mission of the army, like together with the war fighting mission? Or in another word, can be military sector be the protector of human rights or human security? Can it be the force for good or humanitarian warrior? So this is some example of ideological debates. But in my point of view, if we look at the military capabilities, our capability, maybe there's no need for the further discussion. And if we take a look at the rising number of national disaster event, especially from the 1960s to nowadays, so maybe we can conclude that it is undeniable that we need the military sector to provide such humanitarian aid to the disaster victim, and to achieve the humanitarian goal, and to ensure the rights of the right to live and well-being of the victim, and also to guarantee the freedom from fear and freedom from want. So the key question should be how to fit the military sector into the humanitarian affair or humanitarian arena, which is the world of multi-stakeholder, as you can see in this picture. So we have the formal humanitarian actor, like some organ from the United Nations and some organ of the Red Cross, and also the international NGO. And here we are the informal humanitarian actor. And the informal, like military is categorized in this non-formal, informal humanitarian actor. Frankly speaking, most of the time, most of the time, I keep thinking that maybe we should like redefine or rethinking about the definition of some term, like traditional, non-traditional, formal or informal actor. Can the military be or become the formal humanitarian actor if we rethink and redefine the term carefully? Maybe we will have the more proper or appropriate definition of the term which fit into the current international security system. So, however, military nowadays still be as the informal humanitarian actor. So, however, we can sum up that the relationship between these two sectors, or the cooperation between civilian and military sector, is one of the most crucial factors for the successful humanitarian assistance and disaster relief operation. And we need to foster the relationship between them, even though there are so many difficulties and some challenges that we have to overcome. So here we are with the operational debates. like actually so many scholars, including the military actor or commander, are already accept that we need the military sector, and we need the military potential, because this sector have the potential to save human life, right? And to save to guarantee the human security, especially those in the affected area or country. So the operational debates issue like might be how we can link the military actor with the humanitarian principle of humanity, impartiality, neutrality, and independence, especially for the foreign military. How we divide the tasks between military and civilian actor, and can, as I mentioned before, can the military provided the direct assistance to the victim, or it can be only the supporter for the civilian sector, and the concern over the command and control system for the effective CIMIC and the leadership in command and control system as well. This is some key point, because if you can see in the table, there are differences between the military and civilian form of command. While the military form of command tend to be absolute and hierarchical, the civilian form of command is more flexible and rely largely on the coordination mechanism. So here we are another debatable issue, how to create the mutual trust and understanding between these two important sectors. The matter about the information sharing, the communication, the common terminology issue, and to bring about the unity of effort, the unity of purpose, and unified principle. See, and the matter concerning with the last resort principle, especially for the foreign military, and the matter concerning with the cost effectiveness. If we look at how military can provide the assistance to the disaster victim, how long and what period of time should be appropriate for this sector. So all of these issues, I try to find the key from the 6 selected international agreement or guidelines or handbook, which belong to 3 international organizations. As you can see in the table, 2 guidelines belong to the United Nations, the Oslo guideline, and the APC Macro guideline, and 1 from the NATO, the CIMIC handbook from the NATO, and 3 agreements and guidelines and SASOC of the ASEAN. The first one is the ASEAN Agreement on Disaster Management and Emergency Response. The second one is the ASEAN SASOC, which is the Standard Operation Procedure for Regional Standby Arrangement and coordination to joint disaster relief and emergency response operation. And the last one is the ARF strategic guidance for HADR. This is the living document, and the version that I pick up is the version 8 since March 2010. So here I try to compare and find the similarity and differences issue from all of these international agreement, some fundamental and principle. So as you can see, we can see the similar aspect and also the different aspect. And to clarify my point, I reorganize this table into this table. So here we are key fundamentals and principles that we should focus on, or we should reconsider or discuss more about. The first principle is about the humanitarian principle and the principle of the last resort, and the principle of no harm, no cause, and do no harm, the civilian control principle, and the matter of consent and the request of the affected state for the foreign military and self-supporting foreign military, and the limited of time and scale of the maybe foreign military and as well as the national military as well. And there are some issue or matter concerning me, the CIMIC one, for example, the information sharing, the mutual trust and respect and understanding between them, the proactive communication and the unity of efforts, and also the command and control. And the last three, okay, how should I put it? The last three aspects is about how military should provide the role to the disaster relief operation. Should military be the key direct provider of aid, or it just can be the supporter of indirect assistance, or the military access should be a major contributor to the disaster? So if you can see, there are so many aspects that every international agreement touch upon. But do remember that all of the international framework or guidelines are decided for the international disaster relief operation and for foreign military sector. But however, in my opinion, there are some key concern or key item or key aspect that both foreign military and national military should apply or should be stick with. For example, see, common fundamental which almost every international agreement touch upon, like the humanitarian principle, the consent of the and request for the foreign military, the unarmed foreign military, the limit in time and scale for the foreign military, the matter of information sharing for the effective CIMIC or civil military cooperation, and the way how to build or how to enhance or how to create the mutual trust, mutual respect, and mutual understanding between them. And the method of proactive community that will link with the unity of effort. All of these issue maybe the common issue for both foreign and national military. However, there are some debatable issues that I want to point out. The first one is about the last resort principle. Actually, the last resort principle, maybe for both foreign military and national military, especially for the developing country where the civilian sector is not quite ready enough to deal with the disaster relief operation, especially for the large-scale disaster relief operation. So this still have to need more discussion and find some conclusion for this. And another debatable issue is about the civilian control principle, either for the foreign or national military. And the next one is the issue about the command and control system. What type or what kind of command and control system should apply for the effective operation? Should the very popular command and control system, namely incident commander system, should this type of system be applied for every country in this world that face of the disaster or the humanitarian crisis? Should it be applied, the incident commander system? Or it can be another type of command and control system like the joint command and control and so on. And the concern about the limit in time and scale for the national military. As I point out that if we think about the cost effectiveness, as we know that military, the way that military will provide the humanitarian aid is not cheap. It's relatively a bit expensive. So maybe the scope of time and the scale for the national military maybe can be another debatable issue that we have to discuss more. And the last one is should the military be the key direct provider of aid? So let me share my voice. So we know that humanitarian assistance and disaster relief is the multi-stakeholder mission. And for the successful operation, we do need both sectors, both civilian and military sector, and we need to find a way to cooperate with each other effectively. And the matter of last resort principle, the direct assistance, the duration and scope of military cooperation, and as well as the command and control system, in my opinion, should be flexible enough and compromise enough with the nature of the emergency and with the nature of the affected state as well. And if being the first on ground is one of the key indicators to achieve the humanitarian goal, then my point of view, the military capability should not be restricted by the last resort principle. So yeah, as we know that the potential and the capability and the rapid deployment of the military sector is very valuable to save human life and to save human life in the disaster area. So move to the command and control system. Keep in mind, please keep in mind that there is no single command and control option. There is no single or no base command and control option that work best for all HADR. So we have to consider the socio-cultural context of the affected area or affected country. If in that country, especially those developing country where both civilian and military play the active role in providing such aid. So maybe the incident commander, the single command from the incident commander system may not be appropriate with that context. Maybe we should apply the joint command system instead or not to assure all that the resources and tasks are allocated at the most effective way. So communication, the effective way of communication is very important because it is the heart of every relationship, as we know. Okay, last but not least, let me finish my presentation with this slide. So do remember and do keep in mind, this is the key of all kinds of relationship and all kinds of success in almost every kind of cooperation between many sectors in this multi stakeholder world. The key of success is the effective CIMIC or civil military cooperation. The effective CIMIC derives from the good civil military relation, civil military relation, and the good civil military relation will brought about the mutual trust, mutual respect, and mutual understanding. And all of these can be derived from the proactive, suitable communication through the appropriate command and control system and the effective information sharing. And when we have the mutual trust, and when the mutual trust occurs, the unity of efforts will come, and subsequently the success can be accomplished. And that's all. That's all of my voice. So if you have any comments or suggestion or any question, please feel free to ask me. And here my contact. You can either email me after this conference, or you feel free to add me in Facebook, so we can be a friend, Facebook friend. Okay.
Thank you, Ms.
Thank you very
Panita.
much.
Yeah, presentation PhD.
How to stop sharing?
Yes, thank you. Maybe the question and answer session will be the last part. So we will finish first with the speaker, all of the speaker. So I will continue for the second speaker. Miss Yuyun, the second speaker will be Miss Yuyun Wahyu Ningrum from the representative of Indonesia at ASEAN Intergovernmental Commission on Human Rights. Miss Yuyun has graduated from master's degree on human rights Mahidol University, Thailand. And at this moment, she is the PhD candidate at Global Government Law and Social Justice at the Institute of Social Studies in The Hague, Erasmus University, Rotterdam. Without further ado, maybe Miss Yuyun, are you ready? Hello?
Yes.
Oh, yeah.
Okay, thank you very much. Good morning. My name is Yuyun Wahiningrum. I'm the representative of Indonesia to the ASEAN Intergovernmental Commission on Human Rights, or usually called as ICHR. I would like to share my screen to present my PowerPoint presentation. Okay, this one. Okay. All right. So for this opportunity, I think the theme that fit with ICHR, or my role as the representative of Indonesia to the ICHR, is to look at regional human rights mechanism. And for that a particular theme, I look at a specific topic in relation to the opportunities and challenges in protecting human rights in the context of post-pandemic. So we are now in the challenges of human rights situation, as mentioned by the speaker earlier in opening this session, that we are facing with multifaceted crisis, including democracy crisis, raising authoritarianism and military in the region, political crisis, military coup in Myanmar, global health crisis, and COVID-19, especially in COVID-19 situation. Wait, let me, all right. Conflict we are in the region, we also dealing with the conflict. I think the previous speaker already mentioned the relations between humanitarian and civil, military and civil cooperation in relation to the situation of conflict. Maybe linked to this situation. We also, due to COVID, even before COVID, we have an increased poverty, fundamentalism, and policies that continue to oppress the marginalized group, increased cross-border crimes and human rights violations, such as TIP, trafficking in person, migrant workers, asylum seekers, refugees, and we also see more and more shrinking civic space, both now online and offline. There are also digital divide between urban and rural, poor and rich, men and women, and also among the girls. Increased xenophobia, hate speech, misinformation, disinformation, compromised data protection, as we've seen cases lately in Indonesia in particular, that data protection, digital identity have been compromised. There are also increased violence online and harassment online. Due to COVID-19, some of the rights have been delivered interruptedly. There are a number of delayed in performing rights. Not only we deal with challenges, we also have a lot of opportunities. For instance, we have independent national human rights institutions in the region, such as in Indonesia, in Malaysia, and the Philippines. In Southeast Asia, we have 6 national human rights institutions. In ASEAN, we have 5 national human rights institutions. We also have an increased internet connection in ASEAN region. We have cooperation among member states in relation to addressing COVID-19 as a global health crisis, and also to ensure vaccine cooperation to reach out all population in the region. We have a strong civil society in some ASEAN countries, not all, but some. And more governments in the region apply human rights cities or friendly cities or any similar initiative with these different names. Some cities use the term child friendly city or women friendly city. Some cities in Indonesia use human rights cities to fulfill aiming at fulfill human rights at the city level. And also regional approaches to address the crisis, like ASEAN, ICHR, ACWC, and AHA Center. Of course, these all regional organizations as well as the national institution have their own limitation as well. But these mechanisms offer us number of opportunities. So I would like to focus on how ensuring human rights protection in post-pandemic using digital technology. I'm sure there are a lot of effort, a lot of approaches to deal with the measures ensuring human rights protection in post-pandemic context. But in this limited time, I would like to only focus on how digital technology can be used as a new means to exercise human rights. For that, we need to look at beyond freedom of expression online. Whenever we talk about digital technology and we talk about digital rights, we immediately look at or focus more on freedom of opinion and expression online. But let's go beyond freedom of opinion and expression to look at other rights too. So this is the exercise that we need to do together, academics, civil society, human rights institution, both national or regional level, to define what rights in the context of digital era, and also explore on how and what form state obligation to respect, protect, fulfill human rights to be exercised in digital era, and explore the type of human rights violation online and how to prevent the violation happen online. Perhaps some of the way forwards that I would like to suggest here in my capacity as ICHR representative to regional institutions is to place human rights at the center of regulatory framework, standard, and legislation at the regional level, and to provide regional guidance on the application of human rights standards in digital age, which is now not exists. That is why we need to work together to come up with a regional guideline and to address the protection gaps created by the evolved digital technologies. Digital technology evolves very quickly, while we are very late and very slow in coming up with a framework, and so that so protection gaps will be continued to be identified. It is rather ongoing efforts, not ad hoc initiative. And to discourage internet shutdown. In the digital technology era, we are going to be dependent on internet connection and access. So that is why we need to discourage member states to make a shutdown to internet, like many countries in the region now experiencing. Ensure online spaces. We have a strong civil society in some places, but we need also to make sure that their spaces, both online and offline, are secured. And also a transparent and accountable content governance framework that protect freedom of expression and avoid restrictive practices to protect the most vulnerable groups. So these are some of the ways forward. Now, can we do this? And let's check what we have in this region. Human rights are guaranteed by almost all constitutions, the highest level, the highest law in the land. in Southeast Asian countries or in ASEAN countries. Except Brunei did not mention about human rights at all, only to secure that everyone has a freedom of religion, and the religion of the state is Islam. But the rest of the countries, Cambodia, Indonesia, Laos, PDR, Malaysia, Myanmar, Philippines, Singapore, Thailand, and Vietnam have secured human rights. And I mentioned here the chapters in which human rights are actually mentioned. And in Southeast Asia, we have 5. In ASEAN, we have 5 National Human Rights Commission. I mentioned here Indonesia, Malaysia, Myanmar, Philippines, and Thailand. And these are the powers, different powers that owned by each individual national human institutions. I'm not going to read all, but perhaps participants will be able to look at it later on. The region also ratified some of the human rights instruments. The most ratified human rights instruments are CEDAW, Convention on Discrimination Against Women, again, the elimination of discrimination against women, CRC, Convention on the Right of the Child, and also CRPD, Convention on the right of person with disabilities. So these 3 conventions are the most ratified by all 10 ASEAN member states. Countries, Cambodia, Indonesia, Philippines, Thailand are the most ratified countries to international conventions. Yeah, so I mentioned here when the core human rights instruments are ratified for your information. Now, so we are, I just look at what are the modalities we have at the national level, the constitution, the international, the ratification of international convention, as well as the national human rights mechanism. Now, what happened at the regional level? ASEAN, as many of you know, has established ASEAN Intergovernmental Commission on Human Rights, and has included in 2009 and has included human rights as part of the aspiration, the principle and purpose of the ASEAN Charter to establish an integrated regional ASEAN community, as well as to establish human rights mechanism in Article 14. What is the implication of having human rights into the ASEAN Charter? Charter is like a constitution in the national, at the domestic level, but at the regional level, we ASEAN choose the term ASEAN Charter. So it's legally binding document. It was ratified by all 10 countries and now be used as a guidance, as a norm, and how to deal to each other and how to move forward with the regional integration. Now, since 2007, when the ASEAN Charter was ratified, more and more documents in ASEAN from sectoral bodies included human rights. So gradually, human rights not only appear in official document like ASEAN Charter, but also in other official document of ASEAN sectoral bodies. So more and more sectoral bodies embrace ASEAN and make ASEAN human rights, and make human rights becoming the guidance of their regional project. And the inclusion of human rights in the ASEAN regionalism create a regional space in which member states have to talk about human rights. They didn't talk about human rights before, but they talk about human rights in ad hoc level. When there is a need, they talk about human rights. But if there is no need, they don't talk about human rights. But when ASEAN included human rights in the charter and created a body, this creates a space in which member state has to talk about human rights, and member states have to send their representative in this space, which myself is one of them. And it's also created regional process in which now, as I mentioned earlier, the regional community project need to include human rights. So it means in processing the building up of community, ASEAN need to consider human rights and the values and principle of human rights. And this space also creates an interaction and create a new relations between and among countries in relation to human rights and cooperation about human rights. So that's the implication of the inclusion of human rights into the ASEAN regionalism through the instrument, the official instrument as highest as ASEAN Charter. From that point, some of the implication also, as we see, because ASEAN, as ICHR has been here in already for 12 years. So we have mechanism and institutions like such as ICHR or an SCWC, ASEAN Commission on the Promotion and Protection of the Right of Women and Children, and also developing regional norms and human rights, for instance, ASEAN Human Rights Declaration, Declaration on the Protection of Children in the context of migration, and so on and so forth. Providing a platform in which human rights can be discussed, how to integrate human rights into the development plan of individual countries, for instance. So there has been a platform to discuss about it. And then to providing space in which member states talk about human rights concerns. I will go into that later on. And encourage practices of human rights in ASEAN countries. For instance, developing plan of action on human rights or developing plan of action on other issues by considering human rights in it. Working cross-pillar, so not only in mainstreaming human rights at the national level, but also at the regional level. So how ASEAN political security community and ASEAN economic community and social cultural can work together in and considering human rights into the in the process of cooperation and collaboration among each other. But we also need to understand that ICHR is the product of member states. So member states dictate what can or what cannot do as ASEAN human rights mechanism like ICHR or ACWC. It really depends on the level of comfort of each member states, but gradually it create. But having the human rights into the charter and having human rights in ASEAN regionalism, this kind of awkwardness, this kind of rejection, resistance to human rights may gradually relax along the time, and that's the importance of including human rights into the regionalism system. Then you can gradually discuss about it. It doesn't offer change dramatically, but rather evolution process that need to be appreciated. And so this is basic information about ICHR, which you can also find in the number of literature and also in ASEAN in ICHR website. It was established on 23rd of October 2009 by Article 14 of the ASEAN Charter. It works based on term of reference. It has 14 mandates and also guided by ASEAN Human Rights Declaration. ICHR has 10 representatives from 10 ASEAN member states. Each representative work for 3 years in one term, but can be reappointed or reselected for another one term. The purposes of ICHR, one of them is to promote and protect human rights and fundamental freedom of the people in ASEAN. And you can also find more information in the TOR of ICHR. ICHR reports annually to the ASEAN foreign ministers. ASEAN foreign ministers also will be the one to give us instruction on what to do more in relation to the promotion and protection of human rights. ICHR meets twice in a year minimum, but now we have 4 meetings in a year. So our last meeting in this year will be in November 2021. It works based on consensus, consultation, and follow the ASEAN norms like non-interference principle, consultation, consensus, and so forth. These are the function of ICHR. It has 14 mandates, as I mentioned earlier, but for the purpose of making it easier to understand, I categorize into 6 areas as the responsibility of ICHR. First is on standard setting on human rights, cooperation and policy support, a protection of human rights, establishing or developing human rights strategy, research and capacity building, dialogue and engagement. So if you ask ICHR, or if you ask me, what are ICHR responsibilities or role in relation to the right of migrant workers? So these are the responsibilities of ICHR: to develop standard setting on how human rights of migrant workers need to be respected, need to be protected or fulfilled, and cooperation policy support. And this is one of the responsibility of ICHR, to develop cooperation to improve the enjoyment of human rights of the migrant workers, to protect the right of migrant workers, and to come up with human rights strategy, regional human rights strategy in ASEAN in relation to upholding the right of migrant workers. We need to also understand the role of ICHR is at the regional level. The division of labor usually between national, regional, and international level is to complement. So the main protection need to be provided for population are from the national government, and then monitored by the national human rights institution. The role of regional human rights mechanism is to complement the national system. So that is why the regional human rights mechanism usually look at something that the national system cannot do because of their limitation of jurisdiction. So for instance, Komnas HAM, or National Human Rights Commission in Indonesia, or Suhakam in Malaysia, may not be able to, Komnas HAM cannot monitor human rights situation in Malaysia. Malaysia cannot monitor human rights situation in Indonesia because they are limited by jurisdiction, because also their mandate is more national jurisdiction. ICHR should be able to do this, to look at cross-border of human rights situation, and to encourage cooperation among different government, different frontliners of providers, to ensure the rights are protected. So that is why this is a division of labor between national and regional organizations, as well as the international system, for not overlapping. So regional or international system are not there to substitute, but rather to complement. So the system that need to be strengthened first is at the national level. But of course, the world is not ideal. Some countries do not have national human institution. Some countries have national human institution, but weak. But this is something that need to be strengthened. So national or regional or international level cannot overstep the role of the national system at the country. I mentioned about these, some of the questions to ICHR is usually, or to ASEAN, usually dealing with the non-interference principle, the consensus decision-making system, and have been seen as a limitation of ASEAN as well as the limitation of ICHR. Plus, ICHR has been criticized of lack of protection mandate. How regional human rights mechanism like ICHR, without the protection mandate or lack of protection mandate, can protect people in the region? So this is the question that I would like to propose in this paper. Given the limitation of ICHR, can the body address the challenges and maximize the opportunities in the context of the new normal that I mentioned in the beginning of my presentation, to progress human rights protection and promotion. So this is not only a question for me, but also for all of us. But this is my response. Yes, ICHR can, but of course, it takes a process. The body has no protection mandate, has no complaint mechanism. But in November 2019, we managed to agree by consensus to come up with the complaint mechanism. It is very not ideal mechanism yet, but at least we managed to agree on this. We call it three-step complaint mechanism. You can read the steps on the right side of this slide. We also have realizing the Article 4.10 in our TOR to talk about human rights without human rights of other countries without being accused of violating or breaching the non-interference principle. Because it is my personal belief, I'm also a scholar, so I believe that within the limitation of ASEAN that has a non-interference principle, which is not only ASEAN has this, many regional organizations also have this. We still can talk about human rights situation of other countries. I actually look at the example already by the UN, the ASEAN Charter Article 2 also mentioned about non-interference principle, but UN still can have a space in which human rights situation of other countries can be discussed. So looking at this example, there are a number of requirements of to be able to talk about human rights situation. First, you need to agree among yourself. I mean, in ASEAN countries, like in UN, they agree by UN resolution to establish a mechanism to discuss about human rights. Before it was human rights council, committee, now human rights council, in which there are a number of processes there. For instance, universal periodic review, and then UN also has a number of mechanism or system that allow members there to talk about human rights of their countries and human rights of other countries in a dialogue form. So you need a commitment from member states, you need agreement, you need a space. So that's these three factors actually that I copied from the UN to the ASEAN. Now, ICHR now has agreement among themselves to talk about human rights and commitment from all member states in ICHR to talk about human rights. And we have specific agenda to talk about it. Now it calls agenda item 4 to update each other on human rights situation, in which we talk about situation of human rights in Indonesia, and also human rights situation in Myanmar, human rights situation in different countries, without and then can ask question as well without being accused of breaching the non-interference principle. So far until 2021, we gradually arrive at something that can strengthen ICHR, and I'm optimistic that this can go further. Our 5-year work plan also inspired by a number of activities to promote protection. We have included remedies, activities in relation to remedies, complain and manage correspondence, and then grievance mechanism. Grievance mechanism is another term for complaint mechanism. Referral system, this is also an activity to help how referral system at the country level or service providers at the country level can come together. How regional referral system be able to respond quickly to the victim of trafficking in person, or refugees, or asylum seekers, or migrant workers. So now ASEAN countries have services, but they rarely come together. They rarely work together, or rarely having a network to each other. So a regional referral system will be able to facilitate this kind of cooperation among service providers. And then now the 5-year work plan also included ASEAN Human Rights Index, which aim to monitor the promotion and protection of human rights in the region, and learning visit of the representative perhaps to other countries. On 21st of September, we also managed to come up with the ASEAN Human Rights Dialogue. This is like a mini UPR in which countries in ASEAN can brief to each other on human rights, and answer some of the questions. So the difference between the agenda item 4 in the meeting of ICHR and the ASEAN Human Rights Dialogue is that in agenda item 4, it is ICHR representative who update to each other on human rights situation. ASEAN Human Rights Dialogue require the representative of ASEAN member states to update each other on human rights. So the one representing countries, sometimes coming from the Ministry of Defense, the Ministry of Foreign Affairs, or other ministries, and can be also ICHR representative. But so these are two different level of cooperation, conversation. But I see possibilities that a regional system with very weak mandate like ICHR may be able to address some of the problem that we mentioned earlier, but of course it require proper plan and strategy, as well as commitment from ASEAN member states, and perhaps it is not as quicker as we think the ICHR can address some of the problems, but yes, it can. And thank you very much.
Thank you, Ms. Yun, for really, this is opened my mind because of what is actually help actually for human rights in ASEAN. We already talking about how to protection human rights in maybe in the peaceful time and in the war with the first speaker, Ms. Panita, and now we go to the third speaker, Ms. Rika Kurnia, PSHM PhD. She graduated from the Rethinking University, Kyoto, Japan. She was talking about the human rights protection for fisher workers. Ms. Rika, that is yours.
Thank you, Ms. Moderator. Let me share my screen. Assalamualaikum warahmatullahi wabarakatuh, ladies and gentlemen. First of all, let me express my gratitude to the committee for organizing this BILC conference. It is such an honor to be here with you all to share the idea and my research on human rights protections of Indonesian fishers through ratifications of the Work in Fishing Convention number 188 of 2007. Maybe it is quite related to Bu Yuyun already mentioned before. Now we face some challenge in Asean related to the migrant workers. And in these presentations, my focus is on migrant workers who work on foreign vessels, and it's usually called fishers. As we know that the decent work has been recognized as human right, we all know that, and the right to decent work is recognized in UDHR, Human Rights Declarations of Human Rights. Not only the right to work, but also the various aspect of decent work. And in Indonesia, Bu Yuyun also mentioned that the highest level human rights should be mentioned in constitutions. And Indonesia already put these regulations or put these provisions in the constitution in Article 27 that mentioned that recognition and guarantee for everyone to get a job and achieve a decent level of life for humanity. Therefore, we can conclude that the right to get a job and a decent living are essential to ensure its protections, because everyone has the right of welfare. However, until now, the government of Indonesia, because my research is specifically focused on Indonesian case, Indonesia government has not succeeded in ensuring the realization of decent work, and many Indonesian have found their security by becoming migrant workers in other countries, including on foreign fishing boat or a foreign vessel. There are many factors actually trigger these conditions. Some of them are difficulties of finding work and low wage in Indonesia. And also I can mention there are a lot of trigger factors so that many Indonesians are working abroad. However, we should note that in this case, in migrant worker, there are many challenges by the migrant worker, especially for visa. In this slide, you may see that there are challenges faced by the visa, such as the salary problem, low salary, unpaid manipulations in the contract, and also inhuman treatment and poor working conditions, because usually they stay a long period at sea, and therefore they hard to get help because they are isolated in sea, and also long working hours. Another challenge is competence and knowledge issue. Usually, fisher does not have work competence, mastery language, and also does not understand rights and obligations. Also, the recognition and certifications to work as a fisher. And also, there are many issues on labor intense, high fatality and injury rate, and lack of written contracts. And related to legal and documentations, there are also many problems, such as visa or working permit. Usually, they don't have visa to work as a fisher, and also limited trade union representation, fragmented fishing vessel owner organization. Because they are isolated in the sea, it is quite hard for them to be or to get together in a union. And because fisher often live and work on vessel, and also there are many forced labor and trafficking in person on Indonesian fishers. We should also know that this challenge not only occur during the work period, but also before the work period, during the recruitment process, and also after returning to their home countries. Here is the data from the Indonesian Migrant Workers Protecting Agency, or BP2ME, in Indonesia, BP2ME. From 2008 to 2020, there are many complaints received by the BP2ME, and we see here the highest number or the highest report is about unpaid salary. And also many fisher pass away in the destination country. They also got many accidents, or maybe I don't read this all, you may see it later. What I have to stress here, is that there are many complaints, or there are many reports on the issue of Indonesian fisher working on foreign vessels. And if we remember, by the end or in the mid of 2020, there are many cases, or there are many reports on Indonesian fisher working on China's vessel. There is incident of strong allegations of human rights violations and the death of several Indonesian fisher or crew members on China's flag. Belonging to Dalian Ocean Fishing, this is a private foreign vessel from China, and there are many Indonesian fisher got inappropriate, unhuman treatment, such as burial at sea. So this become like national issue, and this, in my opinion, can become a momentum for Indonesian government to strengthen system and institution for the protections officer, because now people in the land, not in the sea, they realize that there are many problems occur or happen to their sister or brother at sea. So, and this is, I see as a momentum for Indonesian government to strengthen the institution for the protection of the sea. And now we should see the regulation related to fisher in Indonesia. Actually, Indonesia already has many regulations or policy related to the fisher. Maybe I will mention here some of them. The first is law number 39 of 2004 regarding the placement and protections of Indonesian migrant worker abroad. This regulation mentioned that every worker has the same right and opportunities without discriminations to obtain a decent job and income, both at home and abroad, in accordance with their expertise, skill, talents, interests, and abilities. However, this law has not been able to provide protection for fisher in accordance with international standards. To get the right, the fisher or the crew, usually some people call it fisher, but some people call it crew of vessel, can only depend on agreement previously made with ship owner. And the second regulation is law number 45 of 2009. This is the amendment of law number 31 of 2004 concerning the fisheries. In these regulations, there is no in-depth and specific discussion related to aspect of human rights in the field of fisheries, but the provision in Article 35A state regarding the requirement of the citizenship of the captain and crew of local and foreign fishing vessel within Indonesian territory, the fisher or the captain should or must be Indonesian citizenships. And the third is law of the Republic of Indonesia, number 18 of 2017, concerning the protections of Indonesian migrant workers. So this regulation is specifically regulate on migrant worker issue. This regulation states that all Indonesian migrant workers must be protected from human trafficking, slavery, and forced labor, violence, arbitrariness, crime against human dignity, as well as other treatment that violate human rights, which is then equipped with descriptions of 13 rights that should be obtained by migrant workers. And the fourth is the government regulations on the Republic of Indonesia, number 7 of 2000s, concerning the marine affairs. These provisions of wage for fishers, which must be based on the standard contained in Article 21, where a crew member or a fisher work for 8 hours every day with 1 day off every week and official holiday with a minimum rest period of 10 hours, and fisher who are aged 16 to 18 do not allowed to work more than 8 hours a day and rest time. This is the conditions. This is the ideal conditions, but the fact is quite different, because usually, or from some report or some article that I read, they only have rest time about 3 hours a day. So it's really below the standard. And the fifth regulations is on the Minister of Marine Affairs and Fisheries of the Republic Indonesia in 2008 concerning capture fishery business. In these regulations, in Article 75, mentioned that everyone who wishes to employ foreign worker on fishing vessel and or fish transport vessel must first obtain a letter of recommendations for the use of foreign worker from the Directorate General. However, in practice, many Indonesian flag fishing vessels employ more than 60% and 90% of crew members who are foreign nationals. So that many Indonesian workers prefer to work as a crew member in other countries. So this is one of the trigger factors. Even though they know the risk and possible cases of violation of human rights and worker rights. The last regulations is the Minister of Maritime Affairs and Fisheries of the Republic Indonesia in 2017. These regulations or the implementation of this regulation is only limited to administrative complement in the fishery business, where if a fishing industry does not carry out the requirement and certification, the government will revoke or not extend the ship business and operational license so that it does not have a business and operational license in the territory of Indonesia. This policy or these regulations only related to administrative thing or administrative issue. From those regulations, I conclude that all available laws show that gaps remain in terms of compliance with Convention number 188, because this convention specifically mention or regulate on fishing fisher or the Indonesian worker that work on foreign vessel. I will talk it later. And if we look at the international instrument related to the issue, we should see the Convention on the Eliminations of All Forms of Racial Discriminations. In the Article 1 and 2, also Article 5 and 5 of these conventions, it mentioned that every country prohibited all form and act of discriminations against any individual groups or organization. Here in the case of Indonesian fisher, they often receive discriminatory treatment from the ship captain in the form of receiving harsh treatment and providing very inadequate facilities. This is contrast with other fisher receive, such as from Chinese fishers. So there's like obvious discrimination could be seen in the treatment. The second instrument, international instrument, we may look is the Convention Against Torture and Other Cruel, Inhuman, Degrading Treatment and Punishment, or CAT. Article 1 and Article 2 of the CAT have regulated the prohibition of torture and other cruel, inhuman, and degrading treatment or punishment, as well as provision in the event of violation. If there is case or in the event of an act of torture, the relevant state must take step to investigate. So if there is something happen related to the issue, the state must take immediate action. And now we look at the UDHR itself, or Universal Declarations of Human Rights. In this UDHR, there are several provisions that conflict with the human rights violation. The fisher phase. We should see the Article 4 concerning the prohibition of slavery. So for analyzing or in the analysis of this case, we should see the Article 4 and Article 5, degrading treatment. And also Article 7, the principle of equality before the law. And Article 24, the right to rest with restriction of working hours and the right to receive wage. The UDHR or the provisions in the UDHR are part of treaty that is legally binding. Maybe we all know that most of countries in the world already ratified the UDHR. And with element of legal obligation for participating countries, and the domestic jurisdiction clause is invalid by reason of enhancing the recognitions of right and freedom in the international community. Now we look at the International Labour Organization policy related to the issue. Before that, we have to look at the ILO Declaration on Fundamental Principle and Right at Work. And this is not only concerning the fishers, but for all workers. These conventions prohibited the forced labor, child labor, discriminations, freedom of associations, and discriminations. And we or every country should respect the freedom of associations and the effective recognitions of the right to collective bargaining. And also, we move on to the protocol to the ILO Forced Labor Convention of 2014. This convention strengthened the international legal framework by creating new obligations to prevent forced labor, to protect victims, and to provide access to remedy, such as compensation for material and physical harm. And this protocol requires government to take measures or to take steps to better protect workers, in particular migrant laborers, from fraudulent and abusive recruitment practice, and emphasize the role of employees and workers in the fight against forced labor. Because this protocol is related to the forced labor. Now we look at the work on fishing conventions, number 188. This is also the regulation or the policy from the ILO. In this convention, several provisions that form the legal basis for protection for fishers. So there are many provisions and article can be used to respond to case or problem of human rights violation in the previous three international conventions. A bit different. This is more specific on the fisher issues. Article 13 to 14 concerning the right to rest, and Article 23 to 24, the right to receive wage, Article 25 to 28, the right to obtain accommodation and food, and Article 31 to 33, concerning the right to occupational health and safety and accident preventions, and Article 38 to 39 mention about the protection from illness, injury, or death. Here in this slide, you might see what issue. Sorry. In this slide, sorry for the disturbance. In this slide, you can see there are many issues that covered by the work in fishing convention, from the responsibility of fishing vessel owner, skipper, and fisher, also about the minimum age, medical examinations, hours of rest and manning, and maybe we jump to the last 2 points. It also mentioned about the occupational safety and health and accident prevention and also risk evaluation, social security, and also protection in the case of work-related sickness, injury, or death. So different from other regulation or other conventions, this convention, Work in Fishing Convention 188, cover broader issue related to the fishers. And here I try to put some ILO policy before 2007 or before 2007 or before the Work in Fishing Convention 188 that push or that push the country or the state to make the Work in Fishing conventions. And here is the trajectory ILO fishing standard from 2002, 2005, and 2007. You may say it later. I think that's all. And okay, here is the conclusions of my presentation today. To sum up what I said before, as a flag state, Indonesia does not currently have comprehensive national legislations to ensure compliance with this convention number 118 requirement. And regulation and legal protection measures for the crew of fishing vessels are still not in accordance with the regulatory standard contained in the Working on Fishing Conventions. And therefore, there is need or the urgency of ratifications of ILO conventions. For the government of Indonesia, this is to protect the human right of the fisher and also as a legal basis for all Indonesian fishers. This is not only Indonesian fisher working on foreign abroad, but also Indonesian fishing vessels sailing in international waters. So not only for individual fisher, but also Indonesian vessel in general. And the urgency to ratify this legislation or this convention is a form of optimizations of the Maritime Labor Conventions in 2006, which was ratified by Indonesia in effort to protect maritime workers. So Indonesia in 2017 already ratified the conventions of maritime labor, but has not ratified the Work in Fishing Conventions of 2007. I think that's all for my presentations. And before I close my presentation, I want to share this quote from Dalai Lama. Peace can only last where human rights are respected, where the people are fed, and where individual and national are free. That's all. Thank you very much, and I'll give back the time to Ms. Moderator.
Yeah, thank you, Ms. Rika Kurniati, PhD, for the presentation, how we actually can understand about the importance of the ratification of this convention in Indonesia, especially for the fishery, because as we know, Indonesia not only have like 100 fisheries, but we have 1,000, maybe more than that fisheries. So to protect them, we should actually ratify the convention number 188 of UN. So from the last presenter, actually we have the present about the rethinking generation of human rights post-pandemic era, which right prevail from Associate Professor Dr. Shahrul Mizan bin Ismail from University of Bangsaan, Malaysia. However, he cannot come today, but he will deliver the presentation by the video. Maybe in the staff could try to start the video first. Hello? I will check the person in charge first. Halo, Mas Fahron?
Yes, sebentar.
Yeah, wait a minute. Actually, Dr. Shahrul could not come here because they have an important meeting in the university, so he only delivered the video by the presentation with the video. If yeah, we cannot do. If you have a question regarding the presentation of Dr. Shahrul, we can't answer it. But maybe if you have a question to Miss Panita, to Miss Yuyun, and Miss Rika, you can raise a hand, or maybe you can type in the chat box. So after the video, they could answer the question. Thank you. You can start it now. We cannot hear the sound.
Hello everyone, Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning. Thank you, Mr. Chairperson. Thank you, Universitas Brawijaya. Right. My name is Dr. Mizan. I'm from the Faculty of Law, University Kebangsaan Malaysia, the National University of Malaysia. Brawijaya and UKM has been good friends for a very long time. I've been to Brawijaya. I've taught in your classes. I've met your students, and I really love and miss the opportunity to meet you guys again. So thank you for inviting me. The title for my presentation today is Rethinking Generation of Human Rights. Post-pandemic era, which rights prevail? The last part of the topic is intentionally phrased in that way, though it may raise some debate. Yeah, it is intentionally phrased that way to provoke everybody's thinking, to think about this. Yeah, the title itself is Rethinking Generation of Human Rights. The reason why I choose this topic is when I first received the invitation from the conference organizer, I look at the title of the conference and basically says that the title is International Cooperation in Promoting and Protecting Human Rights, Opportunity and Challenges in the Midst of Uncertainty. I think it's a very interesting conference, dramatic to a certain extent. We are living in the era of uncertainty due to the virus, the COVID-19 virus. So the COVID-19 pandemic has made us realize that there are so many things that we've been holding on all this while, throughout the decades, things that we have been taking for granted, been accepting it as it is without even sometimes going back into why we believe it to be that way. Those things are actually coming back to us, and this pandemic COVID-19, as much as it is a problem for the world and for all countries, yeah, but I think it is also a blessing in disguise in the way that it actually encourages us to rethink of so many things. Yeah, and one of the things that came to mind when I look at this conference title is about the generation of human rights. Yeah, I'm a human rights law teacher. I teach human rights at the master's level. I supervise PhD thesis. Currently, I have 16 students under me who are doing thesis, and most of them are doing human rights thesis. So, as someone who is from the background of human rights, and I believe there are many of you out there who are like me, and you are very familiar with the concept of generation of human rights. Generation of human rights can be divided into 3 generations of human rights. And I think now there's even some suggestions that it should be, added. There should be a 4th generation of human rights. But anyway, the point is that when we teach human rights, when we read about human rights, when we talk about human rights, when we discuss about human rights, I think this is one of the rarest area that we usually would analyze and think about, you know, because it has always been something that we just accept, okay, and we've been holding on to this belief for so long, yeah. And if you when I receive proposal for students who want to do thesis under me, under my supervision, not many people would go back into this conceptual question, yeah, in terms of this historical question. Which rights prevail? Of course, if those of you who are actually from the human rights background, this last phrase is a bit thought-provoking in a sense, because you can't actually say that one rights prevail over the others, because it's actually coming they actually come hand in hand, yeah. But whether we like it or not, you know, I mean, ideally speaking, we say that they actually are equivalent, all these rights, and they come together, they are interdependent, yeah. They have to be taken as a whole. But when we look at the trend all this while, yeah, pre-COVID-19 pandemic, we will see that most of the time, the emphasis given by the government, the NGOs, the international organizations, the global society as a whole is to basically talk about civil and political rights. The emphasis has always been on the first generation of human rights. And if you look at the Universal Declaration of Human Rights itself, out of 30 provisions, you will see that about 2/3 of the provisions are actually relating to civil and political rights. This is of course this is of course happened due to so many reasons, and one of the reasons, of course, is the historical background behind the drafting process, so on and so forth. But the issue that I'm trying to put forward is this COVID-19 pandemic, okay, has made us realize that perhaps we should rethink in terms of which of these rights should be given emphasis, or maybe it is time for us to actually really take it seriously, not just conceptually, okay, that these rights should come together and they should be treated equally with one another, if I can say that. Yeah. So without too long of an introduction, which I think I've spoken quite long for the introduction. So let's go to my slides. I am going to straight away go into the economic, social, and cultural rights, which are otherwise known as the second generation of human rights. Yeah, what are they? Okay, so that it will be a foundation for further discussions in my presentation. So when you talk about civil and political rights, it's quite, how do I say? I mean, the term could be popular. It's a very popular set of rights. It's something that really, you know, lighten a fire, that will light a fire inside of everyone. And, you know, it's a fight, you know, for those, it's a fight as in like, it really, you know, gives everybody this energy to talk about civil and political rights. You're talking about freedom of religion, you're talking about, you know, the right to fair trial, you're talking about right for someone to live, you know, in his private sphere without any interference. So these sorts of rights are usually the rights that everybody talks about. But what is economic, social, and cultural rights? They are there, but sometimes we take them for granted. So as you can see from the slide, economic, social, and cultural rights are basically rights that relate very closely to our day-to-day life. It relates to our workplace, social security, it relates to our family, the culture, our community, the house that we live in, the food that we consume, the water that we use, the healthcare, and the education. So these are economic, social, and cultural rights. And I've actually divided this economic, social, and cultural rights into categories of rights for ease of discussion, right? So firstly, economic, social, and cultural rights actually one of the categories is workers' right. We're talking about freedom from forced labor, the rights of someone to decide freely to accept, choose work, to have fair wages, to equal pay, and to safe and healthy working conditions, so on and so forth. So if you relate this to the issue of COVID-19 pandemic, you will see that there are many instances where the spread of the COVID-19 is very much exacerbated by the fact that there's not a real safe and healthy working conditions among the workers, especially those who are actually coming from the manufacturing sectors. For example, the factory workers, those who are actually working in the farms and the fields. So these are people who have always been taken for granted. Their rights have always been taken for granted. There is no safe and healthy working conditions. They're living together very, very closely to one another in a very tight space. Yeah, though the rights is actually provided in the International Covenant on Economic, Social, and Cultural Rights in so many of other international instruments. So this is what I mean by when COVID-19 happens, things which you have been taking for granted for so long, things which we have overlooked, it's coming back to us. It's actually forcing us. It's like the nature is trying to tell us to wake up, and look at these issues. Okay, so it's not so it becomes meaningless for us to have the right to vote, to have the right to fair trial when we can't even live, when we can't even go out because of this pandemic. So it means that these rights are important too. And you can look at the green box, the right not to be denied of social security coverage. Yeah, you can see that. I mean, I'm from Malaysia, and in Malaysia, when the COVID-19 pandemic happens and everybody is actually locked down in their houses, they can't actually do the normal economic activities that they are involved in. So they lost their sources of income. So the government is actually allowing for the citizens to actually withdraw their social security savings and whatnot. So if we do not have social security saving, if this right not been protected, which in some countries they are not protected, it will become even worse for those who are affected by the COVID-19. Okay, so this comes back to my root question for my presentation. It makes us really think that these rights should be taken seriously as much as the civil and political rights counterpart. And the other two categories are the right to an adequate standard of living, okay, which I think this goes without saying to be one of the most affected rights when COVID-19 happened. Yeah. So when you talk about the rights to food, yeah, when people are put in lockdown, they are deprived of their right to food actually. And if in the past we've been ignoring this unintentionally, the right to adequate housing, to water, to clothing, yeah. Maybe for those who are so-called in the upper class, or maybe the so-called middle class, yeah, they would not see this as a problem. But when you put the lower income category of people in lockdowns, they are living in apartments, they are living in a house so small with so many members of the family occupying the same space, yeah. So it raises lots of problems like domestic violence. It made it even more. It made it easier for the pandemic to spread, and so many other issues arise. Even divorce rates increased during the lockdowns. So things which we might have in the non-COVID-19 time unintentionally overlook and ignore, it is now becoming a very prominent issue for us to deal with. And of course, the right to health is like the most prominent issue now. Yeah, the right to health facilities when you talk about vaccinating people, you know, and making sure that they come for their COVID-19 tests, for us to actually screen them and make sure that they are put in isolation. All this comes back to the issue whether they have the right to health facilities in the first place. In Malaysia, for example, we have locations which are very remote, and it's which is discovered, which are discovered to be actually having no access to health facilities, or they have access, but it's a very difficult and challenging access to health facilities. So it brings all these issues back to us, right in front of us, right in front of our very noses, so that we take this very seriously. So it brings lots of issues actually in terms of the right to health. It brings also the issue of the ability of the doctors and the health workers, whether we have enough workers who can actually combat and fight against this disease, whether we have enough hospitals, whether we have enough wards and equipment to actually tackle this issue. The other two are the right to education, which I think is also very much affected by the COVID-19 pandemic. When everybody is put under lockdown, then comes the issue of how do we ensure that the children are given their right to education. And the question, the issue that comes to fore is with regards to what about those who do not have laptops and computers and internet access when you are doing online learning? How do we ensure that everybody has access to education? How do we do that? This right has been, if let's say in the past, before the COVID-19, if you were to put them on a scale, you know, and you try to see which one is more important between the right to education and the right to vote, for example, or the right to fair trial, for example. I mean, everybody would, you know, we'll talk about court cases, about abuse of power by the certain political leaders, and you know how the court trials are not made transparent, so on and so forth. Yeah, we talk about freedom of religion, how some religion are actually being discriminated, so on and so forth. But you know, when COVID-19 happens, you know, a simple question like how do we make sure that the children has their education becomes very, very prominent. It's taking a center stage. Yeah. So things like cultural rights, for example, if you look at my screen, you have the bottom box, the right to participate in cultural life, and to have involvement in scientific activities, literary, artistic activities. These are also put on a halt. Yeah, in Malaysia, for example, because the actors and actresses, the singers, the producers, drama producers, film directors, because they can't proceed as normal. So this is actually also affected during the COVID-19. So I think it is time for us to reconsider the myth and misconception that we've been having about economic, social, and cultural rights. The myth that has been in existence before, yeah, is that the civil and political rights are more urgent and they must be prioritized. And economic, social, and cultural rights are more of an ideal rather than enforceable rights. So they take time to be realized, and even if they were to be realized, it cannot be realized at the highest level that it's supposed to reach as idealized. So it can be tackled later. But the truth is that when COVID-19 happens, it is making us rethink how all the human rights are actually interlinked. When you want to say that if you want to say that everybody has the right to vote, which is a civil and political rights, there's no point in giving them the right to vote if they don't have education. So the right to education if people are not given education during this pandemic, not everybody is given education. And even if they are given education, it's not the best quality of education. It will definitely be affecting the civil and political rights, the right to vote, the right to free speech, to free speech, freedom of speech and expression, how someone exercises their civil and political rights is very much related to their education. And how do you give them the right to vote or freedom of religion, for example, if they are not healthy, and if the society is very much infected by COVID-19 virus or any other forms of disease which may affect the health of the community. So it is very much interlinked. This is the first myth that I wish to bring forward. The second one is that the myth has always been that the economic, social, and cultural rights will actually flow naturally from democracy and economic growth. It means that when you actually fulfill the civil and political rights, and there is democracy, there is good, stable government, okay, then this will flow naturally. This is actually not true, because the economic, social, and cultural rights are they are a set of rights that can only be fully realized if specific actions are taken towards realizing them. They are very much positive in nature, in a sense that if, let's say, for example, you say that the right to health is actually inclusive of the right to access of medical facilities, health facilities, for example, means that we have enough hospitals, we have enough doctors, we have enough equipments, But does it mean that when we have when we are rich, when a country is very rich, it has very, very strong economic growth, it has a democratic country, okay? Does it mean that automatically their health system will be good and will be at par according to what is expected for economic, social, and cultural rights? But if you look at the situation at the moment, we have so many developed countries. If you look at during the early parts of the COVID-19 pandemic, you can see that even the most developed countries are actually affected by this. And you could also see, that sometimes the developing or the less developed countries are actually having a better healthcare system in comparison to those in the developed country. So it's actually a misconception when you say that a democratic government, a good economy, will definitely guarantee a natural flow of the realization of economic, social, and cultural rights. So the difference between the civil and political rights and the economic, social, and cultural rights is the fact that civil and political rights are actually negative in nature. It means that what needs to be done is that the government should abstain from activities that would violate those rights. And that would mean that those rights are fulfilled. For example, if you say that everybody has the right to life, for example, and government just have to make sure. This was the assumption before COVID-19. So the assumption is that, if you're talking about the right to life, for example, the government, it's sufficient for the government to enact a law which says that everybody's life is protected. It means that the right has already been fulfilled. But now, when you talk about the right to life in the new era of after COVID-19, it's very much wider than that. It's not just about abstaining from activities that would violate them. The government would have to do some positive actions as well. Because, for example, if the government is not ensuring that everybody has the right to health, which is a part of economic, social, and cultural rights, it will affect the right to life. So it's not negative rights anymore. It is partly negative rights, but it can be fully realized only when it is taken together with, or it is actually implemented together with the positive nature of the economic, social, and cultural rights. And another assumption before this is that the civil and political rights is cost-free. Yeah, it's very economical. You just have to enact the law, okay, and provide regulations, and that will be it. So it's very, very cheap to fulfill those rights compared to economic, social, and cultural rights, where it's very resource intensive. You have to build hospitals that requires money for a right to health. You have to ensure that everybody in the work sector, for example, in the manufacturing sector, the factory workers, for example, their living conditions are improved. They are staying in a comfortable condition. This will definitely raise the cost, and it will increase the major commitment of resources. So, but now when you look at it, you can't actually enforce, you can't actually realize the civil and political rights without taking into consideration the underlying economic, social, and cultural rights. For example, if you say that everybody has the right to life, I think that would be the easy example. But you can't say that they have the right to life. The law protects their life. If anybody kills them or attempt to kill them, those people will be punished. It's not sufficient anymore, because now it's not just about that. It's also ensuring that, you know, they have the right to a healthy condition of living, because those unhealthy condition of living is actually affecting their right to life. I mean, some would disagree with what I'm saying, because you know, the argument could be perhaps it is a little bit stretched. It's stretched a bit too far. But for me, it's very much interrelated, and this is the time for us to actually reconsider this. And you can see on my screen that the assumption has always been that civil and political rights are capable of immediate and full realization in comparison to economic, social, and cultural rights, whereby usually it will take a very long time. So it is more of an aspiration and goals rather than something that you can really enforce. Yeah, it relates to the last assumption, okay, before COVID-19, which is when you talk about civil and political rights, it's very easy to give them a precise definition. So it's very easy to enforce. So we said when you talk about people having the right to life, for example, it's very easy to define right to life means that, you know, your life should be protected. It should not be taken away. You should not be killed. You should not be put into situations which could endanger your life. So this is the assumption, and the assumption for economic, social, and cultural rights, oh, it's much too complex to be dealt with under the rubric of rights, because like I said, it's more of an aspiration, it's goals, it's very, very, very abstract in nature. But now we're forced to actually look into this so-called abstract notions and, you know, put a precise definition to it, because now we have to make sure that they are going to be fulfilled, because not fulfilling them will also affect the realization of civil and political rights. So I think I've used all my time. So thank you very much for inviting me to this conference, and I would like to just show you this last picture, yeah, from my slide. Okay, so thank you very much. And if you need to be in touch with me, you can go to the UKM website, the Faculty of Law, Fakulti Undang-Undang UKM, and my contact details are there. Thank you very much, Universitas Brawijaya, and thank you very much, everyone, for the session. Assalamualaikum, and thank you.
Thank you for the video, Dr. Shahrul. Now we come to the Q&A session. Maybe for the participant, there's a question, you can type in the chat box, or maybe you can raise a hand, and I will try to give you a time to ask the direct question to the speaker. For the first, maybe
actually, I already posed one question.
Yes, Ms. Panita, you want to ask it by yourself, or I will read it?
You can read my question.
Oh, yeah.
Thank you.
Yes. Ms. Panita actually asked to Ms. Yuyut about, by the way, I really want to hear your opinion on the ASEAN way and the non-intervention method and the human rights situation in our region.
Thank you very much for the questions. Well, human rights situation before pandemic and after pandemic are not necessarily good, as all we know. To what extent the non-interference principle or ASEAN ways, which included in the ASEAN way is the consensus, worsen or helpful to the situation of human rights. ASEAN has been criticized a lot in implementing the non-interference principle jealously. But I believe it is not, non-interference principle is not something written down on the stone. It is always changed from time to time. So for instance, for those who read ASEAN literature, perhaps know that the late Surin Pitsuwan, the former foreign minister of Thailand, suggested constructive engagement. Yeah, to be able to address human rights situation in that time, talking about situation in Myanmar. Former deputy prime minister of Malaysia, Anwar Ibrahim, also suggested flexible engagement with similar idea of discussing human rights situation. But it was before the ASEAN Charter included, before the adoption of ASEAN Charter of having the human rights mechanism to be as part of the ASEAN Charter, and also human rights as aspiration and principle of the community building. So now with the establishment of ASEAN Intergovernmental Commission on Human Rights, whether or not non-interference principle and ASEAN way continue to be these stumbling block in addressing human rights. Sometimes yes, sometimes not. In my experience in ICHR, very often that whenever we talk about human rights, I have often tabled the issue of Rohingya. I was blocked with the argument of that we need to respect the principle in ASEAN Charter. But that is why sometimes it didn't come up with a consensus. So when we don't have a consensus, we don't have agenda to talk about situation of human rights in Rohingya. But member states also need to understand that the ASEAN Charter also mentioned about adherence to human rights, good governance, rule of law, democracy, and constitutional government. So, and another article in the ASEAN Charter also mentioned that whenever the issue concern ASEAN as a regional as a region, and then the implication of that situation spill over to the region, we need to consult, we need to discuss, we need to talk about it. So ASEAN Charter actually mentioned about this, but sometimes some of the ASEAN members that only remember the non-interference principle, but ASEAN Charter actually has some kind of condition ASEAN without saying something. So for instance, in the African Constitution, African Union Constitution mentioned about that they respect non-interference principle, but when it comes to genocide, war against humanity, and ethnic cleansing, they should be able to talk about it. ASEAN doesn't have that kind of condition in the charter, but ASEAN say it in different ways. ASEAN Charter mentioned about when the issue become the matter of ASEAN as a region and ASEAN member state need to discuss about it. So that is why these particular paragraph have been used in addressing the situation of Myanmar right now. The fact that the coup is domestic in character, but the implication of the coup spill over to the rest of the member states. Refugees will flow to neighboring countries like Bangladesh, India, China, and Thailand, the closest one. And that should be a concern of more than one member states. And then the number of people got killed, arrested, kidnapped, and so on and so forth also increased day by day. But since ASEAN Charter does not include any provision in relation to sanction of member state who staged the coup, unlike in African Union, so they need to talk about it first. And then despite the fact in February, March and April, a consensus was not reached, but then finally they agree that the situation will spill over to other countries and become the regional concern. And so they need to set the commitment first with Tatmada, with the military government, to say that what happened in Myanmar concerns ASEAN, the rest of ASEAN member states. As mentioned in ASEAN Charter, they allowed to do so. To do so means to say so to the member states, and therefore they need they ask military government to stop. Then they come up with the 5-point consensus, consists of cessation of violence, humanitarian aid, a dialogue, and special envoy. But apparently it was not, these 4 or 5 agreement are not necessarily implemented well. Even special envoy couldn't meet with people that he wanted. In fact, the 5-point consensus mentioned about all relevant stakeholders. So ASEAN decided, based on the lack of the implementation of 5-point consensus, to not to invite the SEC, the State Administrative Council. So I think the media now shown the picture that in online meeting there is only Myanmar without the person there, because SEC, State Administrative Council, also refused to attend the meeting with the intention of boycotting. But since they ASEAN members that already come up with the agreement in the beginning, 5-point consensus, so they know that the absence of Myanmar in the meeting, not because ASEAN, but because of Myanmar. And that is why the meeting, the summit that only attended by 9 countries can be justified. Because in ASEAN, because of consensus, if one member doesn't come, the meeting doesn't happen.
Doesn't happen.
Yes. But in this kind of situation, ASEAN has established an agreement first, based so ASEAN relations with SEC, with State Administrative Council, is based on 5-point consensus. If you don't comply, then there is an implication. So that implication now happened in the summit. Without the agreement in the beginning, 5-point consensus, if the summit now attended only by 9, then the summit is not happening. So there are a number of processes that ASEAN has to do, because ASEAN lack of mechanism of sanction. In African Union, when one member state stage a coup, immediately they will be suspended. Their membership will be suspended, not to remove from membership, but to suspend it. To suspend membership means this member state cannot attend African Union's relevant meetings. What does it mean of not attending the African Union meeting? It means this country will not be able to participate in the decision making of the African Union.
No right for vote, right?
Yes.
No right to vote.
ASEAN doesn't have vote, but in African Union has
African Union.
Yeah, so whatever the decision now made in ASEAN summit will be considered as ASEAN decision, even though it is only attended by 9 countries. But in the chairman's statement by the emergency foreign ministers meeting, it mentioned about Myanmar will be invited, but only can be attended by non-political representative.
I
So,
see.
so it means ASEAN wanted to have 10 countries coming to the summit, but it is the decision of Myanmar not to come to the meeting. So if it is a decision of the country, so what we can do? So that is why they continue. So these are some of the initiative, breakthrough, unprecedented practices in ASEAN. Non-interference principle continue to be there because it is international law doctrine. It is international relations doctrine. It is also in the UN Charter, but the implementation of it, the creativity of implementing it and interpreting it require in this situation. Of course, in this situation in Myanmar, our main focus is the human rights of the people in Myanmar. So that is why anything done at the regional level sounds very far from the ground, but I think the people of Myanmar are in the mind of many leaders. That my understanding, because I also engage with some of the diplomats and I talk to on number of issues. I can sense that yes, it is political issue, but they continue to remind everyone that it is the people of Myanmar become the focus of the intervention. So I also continue to hear many people ask for the removal of non-interference principle as a norm in ASEAN. I doubt if the removal will make ASEAN more effective, because it is, I think, not the norm that is wrong, the implementation it, or the interpretation of the norms that has been used by political actors in ASEAN to limit, to slow down, or to say, I don't want to do anything. And then you cannot say, no, I'm lazy, I cannot do anything on this. I'm not interested. You cannot do that as a part of international community. So that is why you have to use the other, you have to use argument. And the available argument right now is the non-interference principle. So in Africa, they have changed the norm from non-interference to non-indifferent. But again, the application is not necessarily often because again, it is not a norm. It is a threat. It is behavior of the state on how to engage with each other. So whatever norms you have, whether it is good or bad, if you have a good attitude in relation to human rights, a democracy, rule of law, this non-interference principle becoming useless, because it is only a tool to be used by political actors. But I think this is something that need to be established rather than removing a non-interference principle, is the culture of human rights. Make human rights as a culture, as attitude, as behavior, as this consideration of making decision and relations among states. So that's my long answer.
Your point. Thank you very much.
Thank you, Ms. Yuyun. For the second question for the chat from Bu Ikan Diaz to Bu Rika, I'm curious in what is the effort that has been conducted by Indonesia government of our ship crew member who has been exploited in Longxing 6 to 9.
Okay, thank you very much, Bu Francisca and Bu Ikan Diaz. Maybe I will answer the discussion after this with Bu Ika personally. My short answer is that Indonesia has communicated, has a diplomatic effort with China and other countries such as Taiwan and Korea, because the issue not only on China's vessel, but the recent issue in 2020 is on China's vessel. And also I should mention that to date or in progress, Indonesia, the government of Indonesia has already enact and regulations, government regulations on the issue, because before we have migrant worker law, but there is no sorry, because I just like feel a bit dizzy. I thought the moderator before. Before we have already the law, but there is to implement the law, we need certain regulations, the government regulations, and in 2020, this year, Indonesia already has enacted the regulations. And also regarding the fisher, the foreign minister or the foreign ministry already start to make a roadmap to ratify or for the ratifications of the Convention on Fishing Vessel. That's my short answer. Thank you, Bu Francisca.
Thank you, Burika.
And also thank you, Bu Yuyun. You clarify about the declaration. It's not like legal binding. Yeah, it is true because it's only declarations. In international law, declaration is only declarations, recommendations. But after these declarations, we have certain conventions that is bind the countries.
Thank you, Burika. For all of the students or maybe participants who want to ask the question, you can chat in the chat box, or maybe you can raise hand and ask the question directly. For the next question, we have from Bu Hikmatul Ula to Ms. Panita and Ms. Yuyun. As your opinion about the different human rights standard in ASEAN and non-ASEAN country, I mean that not all ASEAN countries ratify important convention. I think it's possible that to have a strong human rights mechanism, will the ASEAN not have a same standard? Maybe to Ms. Panita first.
Okay. But actually, as I mentioned, I'm not the expert in the human rights scheme, but in my point of view, it's not the question is differentiated and all ASEAN countries ratify or not ratify. Maybe it's not necessary for all ASEAN countries, in my opinion, because it is the right of the state which can choose to ratify the international agreement which provide the national interest. If the state consider that if that agreement didn't meet the national interest, maybe should not, maybe it cannot it should not ratify that convention. But as the Yuyun have mentioned, if we make the human right as the culture of the whole region, that's another story. That's another story. That's my point of view. Okay. Maybe Yuyun can clarify the point better than me.
Thank you, Ms. Panita. Maybe another maybe adding some question to Ms. Yuntu. How about the ASEAN Human Rights Corps? Is it possible in ASEAN? Yeah, maybe you can elaborate with it.
Thank you very much for the question. The first one, whether or not is it possible to have a strong human rights system when not all member states ratify the convention? It is possible because it is not depending. The creation of regional human rights commission does not necessarily depending on the record or the compliance of member states to human rights. As we know now, I mean, ICHR was established when countries are still refusing human rights. The Komnas HAM, National Human Rights Commission, was established in 1993 by Suharto, by a dictator. So it is not necessarily a requirement to have all countries in the region to ratify all conventions. I was part of civil society working on to advocate ASEAN to come up with a regional human rights mechanism in 2007, 2009. And we engage with different regions as well. So for instance, civil society in South Asia believe that we are not going to come up with a human rights commission without improved record of member states to human rights. No, we don't have to wait. We can do it now whenever there is a political opportunity. And it is about in international relation, identifying political opportunity is very important, because a political opportunity that appear in 2008, 2009, or 2007, because ASEAN Charter was adopted in 2007, may not be available the current time. The society is different. Imagine Universal Declaration of Human Rights, if it is drafted now, it will be very, very different because society is very different. The political opportunity for ASEAN, for Universal Declaration of Human Rights was in 1947, 1948, right after the World War II. Similarly with ASEAN human rights mechanism. So it is very important to identify political opportunity regardless the record of human rights in the region or the number of ratification. In this region, Cambodia and Timor-Leste is not yet a member of ASEAN, by the way, but Timor-Leste and Cambodia, they have ratified all core conventions because they were under the UN troop. So there is a requirement to ratify all the convention to be able to get help from the UN, and UN troop can come in. But is that the kind of ratification attitude that we want? No, we want member states to ratify the convention because they think it is needed, and by ratifying the convention will help to uphold human rights and to be part of international accountability movement. Because when you ratify the convention, you have to report to the international community on how to implement the implementation of the convention. So it means it's like giving yourself to the international community to be criticized, to be monitored, and so on and so forth. So it requires a commitment from government to be able to do that. United States until now has not ratified the convention on child rights, for instance. They said, oh, our law is already good, but not ratifying the convention means that the US doesn't want to be accountable to international community. Yes, the laws are good perhaps, but they don't want to be monitored and accountable to the international community. So it's different when countries or member states ratify the convention. But again, ratification does not necessarily a requirement to have a strong regional human rights mechanism. In fact, after ICHR was established, gradually the discussion in relation to the importance of ratifying the convention have a space. Before, there was only three 3 countries ratified CAT, the Convention Anti-Torture, but then ICHR provide a platform which member state can discuss about the benefit of ratification of the Convention Against Torture, and now 6 countries ratified the convention. Because there is a platform in which member states can learn to each other on why a convention anti-torture is needed to be ratified, what it is for member states, what it is for our population, what it is for our international reputation. So again, I think it is not requirement. A strong human rights mechanism can be established. I think one of the requirement to make regional human rights mechanism stronger is the individual representative and commitment of member states to move forward, because ICHR is a product of member states. So it requires member states to move the agenda forward, to commit on strengthening the mechanism. But the commitment of member state is not enough. The representative inside ICHR need to find creative ways to move away from all limitation. Like I meant in my presentation, despite the fact that having a complaint mechanism is not included in the TOR, we managed to come up with a complaint mechanism. Despite the fact that discussing human rights in the form of mini UPR is not included in the TOR, we managed to establish that kind of practice. So it requires creativity and vision of the representative to move the agenda of human rights protection forward. And the other question is
HR court.
ASEAN Human Rights Court. I'm not sure it is possible because the legal frame, the legal system in ASEAN countries are very different from one another, because we have a legacy from our colonizers. So for instance, Singapore, Brunei, Malaysia colonized by England. And so they have a very different legal system. Indonesia by Dutch. We also have a different legal system. Philippines was colonized by Spain and US have a different system. Laos, Vietnam, and Cambodia was colonized by French, and then Vietnam was also under US. Well, not a very short time, and they won. They won the war. So we have a very different legal system. So in very short time, I think it is very difficult to find similar ways of how, because when we only adopt one system and then the other countries will say, why that system and why not my system? So you have to talk about that first. But now there is ASEAN ministers meeting on law. They talk about rather exchange of information, how to use CEDAW in court proceeding, how to use international instruments in making a decision on this case, on that case. So they use international instruments in their discussion rather than looking at ASEAN Human Rights Court. If ASEAN Human Rights Court will be established, it shouldn't be established by ICHR, because ICHR is commission. Court should be based on legally binding documents, such as it can be, like having a protocol to charter, for instance. So that's legally binding. We are also established by the charter, but by in itself we cannot establish a court, because ICHR is a commission of human rights, quasi legal system, legal mechanism. And at the moment, ICHR still finding its ways how to strengthen its mandate. but discussing ASEAN Human Rights Court is worth it. But we need to think in long term. I don't think it is going to be achieved in very short time, because again our basis is very different. Our legal basis, our legal system are very different from one another, and that need to be discussed among member states. We also can use another example of because African Union has African Court of Human Rights. In Africa, they also have a different legal system. Those who were colonized by French, by Belgium, by many European countries, they have some differences. Perhaps we can also learn from them and how to reconcile differences. It is not surprises if European Union has European Court of Human Rights, because they almost homogen in terms of legal system. Now the European Commission on Human Rights has merged with Human Rights Court of Human Rights, but when Human Rights Commission was still there, more and more countries readjust and rearrange their legal system. So, but the process took like 50 years for countries to have similar legal system. But yeah, why not? I mean, but we just need to talk about, we just need to think or having a long-term framework in discussing ASEAN Human Rights Court.
Okay, thank you, Ms. Yuyun. Maybe before go to the question from Ms. Panita, I have a question to Ms. Panita actually. How about the one of the action that Myanmar did actually try to stop the humanitarian aid from ICRC at that time? Maybe that just short period. What do you think? Is it permitted under the necessary in the military, under the conduct of facility? Is it permitted or not? Try to stop the humanitarian aid or humanitarian assistance. Thank you, Ms. Panita.
You asked me one more time. Okay. One more time. Sorry.
What I asking about is actually what happened in Myanmar at that time when they trying to stop ICRC aid and some humanitarian assistance from ICRC, and what the government Myanmar said is one of the necessary for the conduct of facilities. Is it permitted when the one country under the armed conflict maybe or under some situation, they're trying to stop humanitarian aid or humanitarian assistance? Thank you.
Very, very, very interesting question and very difficult to answer. Frankly speaking, I have no idea about the issue. May I? Yeah, I have no, opinion and knowledge.
Actually,
sorry.
Sorry,
I will search for more knowledge and for more information about this matter. But thank you anyway.
Okay, it's okay.
Can you help me?
No, I'm just asking about how about when someone trying to help you, but you don't want to get help when in the military situation. I think that's
I'm not familiar with the case, but
I'm not. Yeah, neither do I.
With the current situation in which AHA Center also got no access to people to distribute the humanitarian aid. Humanitarian aid has been transferred based on as the implementation of the 5-point consensus. AHA Center has sent humanitarian aid to Myanmar, but through SEC, State Administrative Council, and Myanmar Red Cross. They cannot go in, AHA Center cannot go in to distribute directly the humanitarian aid. Similarly, AHA Center was also offered support to Indonesian situation, earthquake in Palu, but AHA Center only can send the humanitarian aid to the camp, to the center that appointed by government of Indonesia. And then it is government of Indonesia, local government in Palu, the one who distribute. So I think this has, in general, I think this has something to do with sovereignty. Special rapporteur cannot enter the country without the invitation of the member state, because it is jurisdictional authority of government. So I think that's the basic rule, that we need to get the country to allow anyone to enter the country.
The land.
Yeah, so we cannot enter the country without passing the immigration. No? Yeah, that's almost similar. But in the situation of conflict, like right now in Myanmar, the current situation, in which we do not trust the SEC, the State Administrative Council, to distribute fairly to those who are affected by the conflict, especially on the ethnic nationalities areas, ethnic areas. So that is why AHA Center asked to have access to those areas and people, but it's not granted by SEC. Is it okay? Is it still following the international law? Generally, yes.
Yeah,
But
we still need to have the consent of the state for the international contribution, because that's the principle of sovereignty of the state.
Okay, thank you. For the last question is for Bu Rika.
From me.
Yeah, from Ms. Vanita. I wonder, in Indonesia, is there any province that the majority of its population is the migrant workers?
Yeah, because in Thailand we have like a few provinces that the majority of population is the migrant worker and from Myanmar as well. So I wonder if there any province in Indonesia, and if there is, or there are some, what the situation, what the human rights situation in that particular province.
Thank you, Anita. Actually, maybe quite different from Thai, or I ever heard that in Philippines, that the majority of populations in the province are migrant workers, but quite different in Indonesia. As I know, there's not a majority of the populations are migrant worker, but there are some provinces that contribute or have many migrant workers, but not the majority. And especially in Jawa, West Java and East Java, and also Mid Java, and also there is a province outside Java, West Nusa Tenggara, I guess. It has many migrant workers, but not the majority of the population.
How your government deal with the problem of human rights violation is in that province? How to deal with, how your government deal with?
Actually, we have not the problem or the challenge face the migrant worker. Usually, most of the case, if I'm not wrong, maybe Bu Yuyun have more knowledge on this issue. But most of the time, the problem is when they are in working countries, or working countries. We cannot say not in working countries, but also in after returning home, and also before working on in the recruitment system. There are many challenges faced by the migrant workers, and we have agency, Indonesian Migrant Agency, that deal with the issue. So if the migrant worker or a migrant worker has problem, they can report to the agency. So as I show you all before, there are many cases reported by the migrant workers. Not only before the working times or the working period, but also after returning, because some insurance they didn't get paid, or they don't receive the insurance, something like that. But we do have an agency to deal with the issue. Am I correct, Bu Yuyun?
Yeah,
because
thank you very much.
Bu Yuyun is practitioner and usually has many information on the issue.
Right.
Maybe the different between the contexts are quite different. Some provinces in Thailand dominated by migrant workers from Myanmar. We are the source of migrant workers. So for instance, areas that Ibu Rika mentioned, East Java, West Java, East Nusa Tenggara or West Nusa Tenggara, they are the pocket of migrant workers sending abroad. But now, lately, we got migrant workers from China. I think it's one area, I can't remember, in Sulawesi. But it's only on that area, the mining companies there. So it is still unclear how situation there, but what we continue to hear from media, for instance, there are a number of jealousies from the local resident towards facilities or they allow to work, like during pandemic while we are locked down. Why we receive these migrant workers from China to work in mining, so well we cannot work because we have to work from home. Why they can come to our country and work on the mining? So there are a number of jealousies, there are a number of questions from the people in that area. But that's only I think one location. The rest, we are source of migrant workers. So usually the question was really about the family left behind, like children of the migrant workers, the family of the migrant workers who left, who work abroad, and how the process of return to the country, and what in this kind of situation, and during COVID, for instance, Indonesian migrant workers who return home got stigma of being the carrier of the virus. So many issues, whether or not you are a pocket of migrant workers or the area becoming dominated by migrant workers from other countries.
And it's about the quality of the migrant worker as well, and the better behavior in comparing with the nation, like the Thai labor. Yeah.
Okay, thank you for all of the speaker for today. We already have a great time together that we know many kind of things that's actually human right, and not only happen when we are in the peace situation, but also in the war situation, and how about they can help us actually to protect us from maybe in the migrant when we are sent abroad, or maybe in any kind of situation, even in the pandemic, that a lot of people actually get impact from this pandemic. And we hope that the pandemic can be done maybe, or maybe we can getting more stronger so we can fight with the virus strongly. Thank you so much for all of the speakers, Ms. Panita, Ms. Yuyun, Ms. Rika. Thank you for the time, and maybe we can meet in another situation, maybe, or in another conference. Maybe we can invite you in Malang. Thank you so much, all of the participants and all of the students here. Thank you. I will And don't forget at the 3 p.m., 3 p.m., we have the chamber discussion. And if any of you want to come to each chamber, you can just copy in the Zoom in the same link, and there's a breakout room, so you can choose which room do you want to join. Thank you so much. I will return the time to Miss Belinda. Miss Belinda, time is yours. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much. Nice to meet you
Thank you for
all.
sharing,
Thank you.
Vanita.
Stay safe
you.
and be healthy
Yes.
during the COVID-19
We will meet you in another occasion.
crisis.
Thank you. Thank you.
Thank you, Miss Francisca. Ladies and gentlemen, after this, we need to take the break, and next panel session will be start on 3 p.m. So I hope you can join again for next session. Thank you.
Terima kasih Bu Yuyun atas partisipasinya. Nanti kita undang lagi, Bu.
Thanks for everyone. Bye-bye.
Terima kasih sudah diundang.
Bye. Bu Yuyun, nanti sharing banyak ya dengan kami.
Luar biasa.
Ya, sama-sama.
Terima kasih.
Masih
Sukses.
banyak.
Terima kasih Pak Herman.
Nanti ngobrol-ngobrol sama Aicer ini.
Ya, boleh.
Going
Welcome.
to fill the attendance form on. Okay.
Thank you, Gig. See you next time.
See you.